Like any good lawyer, I'm going to start out my talk telling you I'm not going to give you any legal advice. So what the deal is anytime we talk, give a seminar, we have to mention at the beginning that this is designed to start some thought, to stimulate discussion, but it is not designed to be individual legal advice to any one in particular. So we have to do that. Also, I have to mention that if I do make a joke, it will probably be bad and it will probably be badly timed. So who I am or who we are is Thompson Law Prof LLC. We have attorneys licensed in South Dakota, Minnesota, and Iowa, soon to be Nebraska. We do estate planning and business planning. We really don't do anything else, and that's my beautiful face. My name is Doug Thesenvitz. I grew up in Sioux Falls here in South Dakota. Sioux Falls kid all my life, went to USD Law, have a Cocker Spaniel. I'm licensed in South Dakota and Iowa, and I focus on estate planning. So our lawyers in our firm, we have Andrew, and he's our managing lawyer. Kelly Benson is our trust administration lawyer. I'm a planning lawyer for Iowa and South Dakota. And Travis is a planning lawyer for Minnesota and South Dakota. And we always like to honor and just mention our founder, who's Carolyn Thompson, who passed away in September of 2019. And there's a little quote of hers that I'd just like to share with you. And she said, "We believe your legacy matters. You are important to this world. We are honored to help you connect the wisdom of the past as we assess the realities of the present. With that understanding, we help you build a legacy plan that defines your loved ones, that defines for your loved ones and charities what success means to you." So we always like to just honor her for a second whenever we do this. So I'm just going to talk about some basic estate planning and some basic estate planning tools. Your basic tools for pretty much any estate plan are going to include powers of attorney. A lot of estate plans will have some transfer on death planning or some pay on death planning. There will be wills and there will be trusts. And so I know some of you actually have an estate plan. If you do have any of these in place, just ask yourself, how old are these plans? Since you made your plan, has your family changed? Or has the law changed since you made your plan? And we're going to talk about some law changes at the end. I don't know really about how old your plans are or if your family has changed, but you know the answers to that. So the basic powers of attorney, so these are where you are going to appoint an agent to act on your behalf. A durable power of attorney is a power of attorney that allows somebody else to act on your behalf as your agent covering your property, okay? Powers of attorney, durable powers of attorney can be springing, which means they come into effect upon a certain event, or they can be a hybrid, which means they're in effect now for your spouse, but springing for your kids, or they could be immediate. So if you know that things are going down for you, you can put together a power of attorney and say, I need somebody to take over as long as you're still healthy now. Then there's the healthcare power of attorney. A healthcare power of attorney helps an agent to speak for you if you cannot communicate your healthcare desires. And then the difference between a healthcare power of attorney and a living will or advance directive is this. The healthcare power of attorney, that agent speaks for you while they are present and you cannot talk. The living will or advance directive tells the doctor what you want on a piece of paper when your power of attorney can't be there. So some more basics of estate planning, which a lot of plans are going to have, will be beneficiary designation. So we all know that when we've bought a life insurance policy or an annuity or something like that, we always are told, hey, we've got to put together a beneficiary designation. And oftentimes we just do our spouse and then our kids, which is pretty generally what we see with life insurance. And that's the most common. But remember that a beneficiary designation will always supersede your will. It will always supersede your trust. If you should happen to be divorced, a beneficiary designation on a retirement plan succeeds your divorce. In other words, or supersedes your divorce. So in other words, if you get divorced, you got to change that beneficiary designation or you might have your retirement plans going to a prior spouse. We can transfer LLC interests through pay on death designations. We can even transfer land with transfer on death deeds. So those are some pretty handy tools. Another basic estate planning tool that a lot of people use and absolutely valid, joint tenancy with right of survivorship. Remember, this will supersede your will or trust. And for most married people, if we just have our house and we want our spouse to be in our house when we're done, the joint tenancy just works because we don't even have to put that through a will. It again supersedes your will or trust. Although sometimes we get a lot of do-it-yourself stuff where we'll have, people will say, well, hey, the joint tenancy with my wife worked fine, but here's what the problem is. Now I need my child to be on the account because my wife has now died and I want my child to be a joint tenancy. The problem is now you've made a gift to your child. You're exposed to your child's creditors. At death, you lose the step up in basis. And then the joint owner is the sole owner. So if you had 3 kids and you made one the joint owner, that kid gets everything that was in that account. Another thing that can happen with that is if you go down to the bank and you just say, hey, bank, I want you to give my child the right to sign on this account versus having joint ownership. I just want them to be able to write checks. That's fine, but make sure the bank does what you ask them to do. We have this experience in the office where people come back and say, oh no, they just have signing authority. And then we go look at the account and the account tells us that it's actually a joint account, and that can create problems. So beware when you set that up at a bank. Another planning tool, and probably the most common, is a will. And a will is if we don't have a will, you should have at least a will. A will was sort of the gold standard 30 years ago. When you're alive and well, a will really doesn't do anything. If you're incapacitated, a will doesn't do anything because a will sits there in your drawer or in the envelope you got from your estate planning lawyer, gathering dust until the day you die, when your personal representative has to take it down to the judge and say, hey, judge, here's the will. Let me be the personal representative. And then that's a public proceeding that happens. If you are incapacitated and just have a will, you could end up in a guardianship or conservatorship court because nobody has the authority to act over your property or maybe over your healthcare decisions. So a will can be a little bit problematic in the things that it doesn't do. So then the next thing we go to is the basic estate planning tool is a trust. And I'm just going to talk a little bit about trusts, and I like to think of trusts in a couple of ways. All trusts are revocable or irrevocable. So when we think about a trust, it's easiest to kind of describe them when you think, well, look, a trust can be thought of as a treasure chest like I've got up there, and especially a living trust. And if it's a living trust, that means it's a revocable trust. And I really like the idea of calling it a living trust because when you say revocable and irrevocable, nobody really knows what I really said because revocable and irrevocable sound so much alike. So I like the term living trust for revocable trusts. The door is open, or the top of that treasure chest is open, which means we can put things in that trust. We can take things out of that trust. So the parties in a trust are the trustor. The trustor is the person who is placing their trust in someone else. The trustor or the grantor is placing their trust in a trustee for the benefit of the beneficiary. And we'll see those again later. All trusts can have these other optional roles, and that would be a trust protector who's sort of a meta trustee who steps in when they're needed, a distribution trustee or a committee to make distributions to decide when distributions need to be made, investment committees and things like that. So all of these agreements, all of these documents require something called fiduciaries. So fiduciaries and guardians are what your agent in your healthcare power of attorney and your property power of attorney are. They're fiduciaries. Your trustee in your trust is a fiduciary. The personal representative in your will is a fiduciary. So what makes a good fiduciary? A good fiduciary is somebody who's going to be willing and available to act. And I think that, you know, most of you are probably going to name your children as a trustee or as a personal representative, and your children are probably going to be there and ready to act. But do your children have really good experience managing other people's assets, and it may be easier to find someone who would manage another person's assets than it would be to find someone who would manage another person's affairs. The other thing I think about is we think about our agents, and sometimes a healthcare agent might be, you know, my son who's the doctor, but my property agent might be my daughter who's the CPA, you know. So we need to think about things like that. Another thing that's often just really important is making sure that your fiduciary has some familiarity with your family values, with your family background. So we can always use a person or a professional or corporate trustee. Now, you know, our next speaker is a professional and corporate trustee, and they have a lot of advantages. Corporate trustees are held to a higher standard. They're basically held to the same standard that banks are held to. And they are held to a very high standard, and they have a lot of advantages like that. They're not going to run away, or they're not going to develop any problems or things like that. So, and they don't get old and die on you. A person, on the other hand, can have advantages because they're going to be less expensive. They might be more familiar with you. Sometimes you can handle the more familiar with you things in your trust document by putting your instructions down very clearly. Sometimes we have two children and we want to make them both the trustees, so we make them co-trustees. And that's okay, but then we understand that everybody has to sign everything. So next I'm just going to talk a little bit about the estate tax exclusion, and I just want to talk a little bit about federal estate taxes. And right now, most federal estate taxes aren't a big problem because each individual can pass $11.5 million. And you can see that it's been going up year after year, and it's scheduled to continue to go up until 2026. So right now, with an $11.5 million exemption per person and the estate tax at 40% and something called portability, which we don't have time to get into, and we can give away $11.5 million at a 40% tax rate. You know, is there a lot of reason to do estate planning? And we think there really is, because we really don't believe that estate taxes should wag the estate planning dog, okay? So again, want to point out to you that right now it's $11.5 million. That 11.5 came in 2018. Want to point out that in 2025, that's scheduled to sunset at the end of 2025. We think it's going to be about 14 million. In 2026, it's going to go down to 7 million. But the other thing I want to point out to you is there's always the possibility of governmental change. And some of that can be kind of interesting, because beware, Bernie Sanders wants to change the estate tax to, rather than $11 million that you can pass estate tax free, he wants to take from 3.5 to 10 million. He wants to take 45% of that, right? And that'll be due like 6 months from the date of death. 10 million to 50 million, 50%. We know that there will be elections, and the only thing we know about our government is that things will change. So even though estate taxes aren't the only thing to be concerned about, sometimes the changes in the law are something that you need to be concerned about. And yes, Congress does need to pass these proposals. So if Congress changes and the presidency changes, that can change these things, and it may or may not, who knows. If today you have a combined net worth more than $5 million, you should really think about planning. If your combined net worth is more than 10 million, you should think about planning. I want to talk to you about just a little bit of a case study, and I'm going to have to run through this pretty quick. So Dean and Rita, let's just imagine that they're a couple of farmers. And we're going to just pretend there's some clients who came to our office. Dean and Rita have 4 kids. Lloyd, who wants to sell the farm yesterday, and Ralph, who wants to be the farmer, and Molly, who's a great daughter and has a special needs kid, and Jean, who is another a superstar too, and she could stay and manage things if you wanted to. Dean and Rita come to our office and they tell us we've got these goals. We want to be fair to all of our kids. We want to treat everybody equally. We need to keep family land in the family. We want to pass assets to our grandchildren in the event one of our kids dies. We want to preserve assets because we've got a spendthrift kid, because we got Lloyd back there and he wants to sell the farm and spend all the money. Dean and Rita have told us that their farm is worth about $6 or $7 million. We want to prolong assets because one of our daughters has a disabled child. We want to protect assets in the event that one of our kids gets divorced. We want to make sure there's no estate tax, and we want to avoid probate. So we're going to put a trust together. While Dean and Rita are alive, they're going to occupy all 3 positions. Okay, they're going to be the trustees, they're going to be the trustors and the beneficiaries. So their life really doesn't change at all. It's absolutely business as usual. When you're alive, you are in control of your trust. That door is open. We can change the trust. There's no change in your property tax. There's no income tax changes. There's no new tax forms to file when you use a living trust. So then some time passes after they put the trust together, and what happens, obviously our first spouse passes away, and we always pick on gentlemen because men don't live as long as women generally. So Dean passes away. What's going to happen when you have the trust? Well, when we have the trust, first thing they're going to want to do is meet with their estate planning lawyer. And at the first death, depending on how complex their plan is, there will be some work for the attorneys to do in terms of making sure all of the assets get titled correctly in order to reduce costs during trust administration. So we like to make sure that that after the first death, we get everything set up the way it's supposed to. Now, in almost all cases, there will not be an estate tax at the first spouse's death. And so specifically for Iowa, if we're going from one spouse to the next spouse, there will be no state inheritance tax either, because we can go straight to spouses. If you're married to somebody who is not a United States citizen, we've got some lower limits on how much we can leave to our spouse without paying an estate tax. So if we've put together this kind of a plan here with what I'll call an A-B split, remember I said they're worth about $6 or $7 million. What we're going to do is we're going to have something called a family trust, and that family trust is going to be a protective trust. It's going to have a little creditor protection. It's going to have divorce protection. It's going to leave that income can go from that family trust down to Rita. Rita is the sole beneficiary of the survivor's trust, and she can completely change that. In the family trust over there on the B side, Rita gets the income from that while she's alive. Good news for senior citizens is, I want to just skip here. The good news for senior citizens is spouses are living longer. Life expectancy has increased. So what happens after your first spouse is gone? The second comes in. So meet Frank. If we've built that B trust correctly, we might put a prenuptial trigger in there so that when Rita gets remarried to Frank here, Rita has to sign a prenup or she gets cut out of everything that's in the B trust, and that B trust then can go down to Dean's kids, and they can be kept away from Frank's kids. So when Rita dies, then what do? Well, there's going to be a trust administration. If we've got everything titled properly and we did everything right at the first death, there won't be any probate to do. We'd ask that you come in, you meet with us. We're going to title your property. We're going to get the appraisals. We're going to pay the bills and expenses. If there's any federal estate tax returns to do, we'll take care of those. State estate tax to do. We'll publish notice to creditors, and after we run our period on that to cut off creditor claims, we'll distribute assets to heirs. So how are we going to distribute the assets to the heirs will be some pretty important things to think about. When we are making distributions to beneficiaries, we need to remember, like I said a minute ago, that the estate tax tail should not wag the planning dog. We need to think about these kids down here. Remember, I told you Lloyd is kind of a spendthrift. He's a bounder. He wants to sell the farm. So we might want to prevent that from happening. There's some common things that most people are concerned about for their kids. One is divorce. Half of your kids' marriages are going to end up in divorce. A lot of times kids are getting sued. Sometimes there will be estate tax problems. So we've built something called a Century Trust. Century Trust is a trust that can provide divorce protection, creditor protection, estate tax protection. It provides succession planning for your children, and we can make sure that this property goes to your lineal descendants with the Century Trust. This is not a special needs trust, so if we had that special needs child, we're going to need to put together a special needs trust, and all I'm going to say about that is a supplemental needs trust is a trust that's designed to supplement but not supplant governmental benefits, so that if you have a special needs beneficiary, you can make their life better, but you don't have to spend all of the assets that they have before they run out of money. Okay? So something that happens is farm families. How is the rent going to be determined if siblings have to agree to rent the land? Who's going to rent the land? Can a farming child afford to pay the rent, or can they afford to buy? So what happens is, you know, we end up with fights between these kids because some want to sell, some don't. If we just go straight out to these kids, one kid probably won't be able to buy out the other three. That's a divide and destroy plan. So a better alternative is to put everything into what we're going to call a legacy land trust. A legacy land trust is a trust. We can use a legacy land trust, or we can use a land company. Upon the death of both spouses, we'll drop the agricultural real property into this trust. We'll determine our rental rates in the trust, our purchase options, rights of first refusal, sale restrictions, and then we'll put in there, when does this terminate? How do we get to the point where we're going to terminate? It's just real brief on how that works, but that can preserve that land, keep the farm in the family. And land companies, another way to do while you're alive or while you're past, and while you're alive, you can put your land into a land company or a limited liability company. And it's a good way to do generational planning. And I think that Amy is going to speak about that just a little bit. I want to talk just a little bit about this, and I want to get this in as quickly as I can. In 2016, South Dakota put together some legislation called a special spousal trust. And it's a special trust that requires specific language. And what the South Dakota legislature did is looked at Alaska and Tennessee, who have been doing this for 15 years. And it's worked for 15 years in these other states, and South Dakota thought, hey, we should get in on this too. So what they do is we can transfer property into a trust that we can transfer the property into the trust as community property, okay? We have to have a South Dakota trustee, and this is a great idea for highly appreciated assets, because what happens is at the first death, all of the property that we put in to that special spousal trust will get an entire step up in basis. So let's just talk about the basics of cost basis really quick. I just need to check something here. Oh, okay. Oh no, maybe I'm at the wrong site. So the basics of cost basis or capital gains. Let's assume that we buy jointly an asset for $100, and it's got a fair market value of $100. And the The fair market value of $100, time passes, we get some good years. The basis is $100 because that's what we paid for it. The fair market value is now $1,000. If while we're alive, we're going to sell that piece of property, we're going to pay capital gains tax. Here, 23.8% or $214 of our $900 is gone in taxes. So think about that with just 1 acre of land, or if you've got 1,000 acres of land that's highly appreciated. We don't like that thing. And so what happens a lot is farmers don't sell their land because they don't want to lose that capital gains. So the default adjusted or stepped up basis works like this. Mom and dad buy property together. It appreciates over time. The fair market value is $1,000. The basis is $100. So if there's a death and everything goes to the spouse, the surviving spouse, her basis is $50 because she had half of the 100. The fair market value, and then his basis is 500. So you got 550 in adjusted basis. Fair market value is 1,000. If you sell it, you've got $107 in capital gains taking out from our 450 gain. So that's another non-desirable result. So if we do it like this, if mom and dad buy the piece of property, we go up in value, we leave it to the spouse, and then the spouse keeps it, and the spouse dies and passes it on to her heir, then there's no gain. Well, that's the best way to get things done, with no gain. So what we like to do is the special spousal trust. The difference here you see is the $100, the $1,000 value. The adjusted basis is $1,000 at the first death. The thing that's really interesting about this is you can do this with all highly appreciated assets. So what happens is this: if you buy a tractor, you depreciate it out, you've got it in a special spousal trust, it gets a full step up on the first death, the surviving spouse or her kids can now redepreciate that tractor down to zero or sell that tractor with no capital gains. So this is just a little bit of that. I wanted to tell you, so what's the downside? So the upside is this: we get a full step up in basis at the death of the first spouse, and that's the biggest upside. What are the risks? If you get divorced, it could mess up a prenup. So if you have a prenuptial agreement, the special spousal trust might be a problem. If you're not worried about divorce, if you've been married 35, 40 years and you're sure you're not getting divorced, that's not an issue. One issue is this: you could have an IRS challenge. The IRS could say, hey, wait a minute, we're going to challenge this. But what I said a couple of minutes ago is pretty applicable. Alaska and Tennessee have been doing these for about 15 years. South Dakota has been doing them from 2016. There is no reported case. There is no reported case of the IRS ever challenging one of these. So as far as we know, it works. And as far as we know, we can take property from another state and put it into South Dakota. That's what Alaska has been doing for 15 years. That's what Tennessee has been doing for 15 years. South Dakota thought we might as well get in on the party, essentially. So, and the other thing that you have to be aware of is you can't do it on your deathbed. And so when I say you can't do it on your deathbed, that means this: it has to be in effect for 1 year before you're good. Where am I? So who is the special spousal trust for? People who have long-term capital assets. In other words, assets that have grown in value. It works with stock, it works with farmland, it works with farm equipment. That's just property we can put in this special trust. It's great for highly appreciated assets, assets that have been depreciated and could stand to be redepreciated. So, you know, who should have an estate planning review? Any person who owns any property, anybody who might become disabled, any person who might die really needs to have an estate plan. And I saw some of you people don't have them at all. talk to your lawyers, okay? Call us. We're happy to do that. We meet with people. We're 90 minutes. There's no charge. And I see I'm just about out of time, so I'll go to the last slide. It's what we do because your legacy matters. And I'll turn it back over to Maggie.
Thanks, Doug. Amy, from here, if you want to just go ahead and share your screen and you can kick off.
All right, I will do that. Just a moment here. And I'm going to start here. Okay, so, oh, I'm sorry. Go back up there. So my name is Amy Williams. I am a trust officer for Cornerstone Private Asset Trust Company. We are a South Dakota trust company. I'll talk about what that means in just a little bit, but it is a very important distinction. First, I'd just like to share a little bit about myself. I hail from the Mississippi Delta. I have been in Minnesota, though, for 21 years and raised my 3 boys here. I do, in full disclosure, have a Cyclone in his junior year. So we're big Cyclone fans. I want first, I mentioned being from the Delta because I want to thank all of you for your time and your efforts and your sacrifice for all of us, because without you, I don't know what we would do. I grew up with a great appreciation of the land and what that means for my family. So anytime that I am able to work with you folks, and I have been able to do some work with Iowa farmers in my career with a former trustee, and I'm glad to have the opportunity to do that yet again. So I know how precious your evenings are, so I want to thank you for taking out the time. Cornerstone Private Asset Trust Company, as I mentioned, is a South Dakota trust company. We're organized under South Dakota law, and we report to the South Dakota Division of Banking. When our company started out, really our holding company started out as accountants, and they decided that their clients, who were entrepreneurs primarily, would need wealth planning and would also need estate planning. And so they built both of those areas out of the business. Cornerstone is the result of that. And in their wise decision-making, they chose South Dakota to organize so that our clients can have the benefits that are under South Dakota law. And as Doug so well put in his discussion, South Dakota law is one of those states that has put asset protection in the forefront of its trust law, and it is actually ranked #1 in the United States for asset protection. That is very important, especially for Cornerstone clients who, as I said, are primarily entrepreneurs, because it is protecting whether it is their land interests or it is their business and or business from creditor protection, and also in the unfortunate event of a divorce. It also allows for the longest ability to pass assets on to future generations. Other states have shorter timeframes for the continuation of passage of assets to future heirs. So we take our clients and their interests, their legacy interests, very seriously, and the result of that is becoming a South Dakota trust company. As a result, if you do use Doug or his firm, for instance, to build a trust, and you decide whether you decide to have one or more of your children or someone else as a co-trustee, and or you place Cornerstone as the professional trustee, then your assets will have will be sitused, as we call it, or organized under the law of South Dakota, and therefore you will be able to avail yourselves of the protections that are afforded to all South Dakota trusts, having Cornerstone as the professional trustee. And it's a very important point that we are able to work in concert with anyone else that you might want to put as your trustee. And we also work with any other folks that are involved in your estate plan. For instance, your attorney who drafts the trust, your accountant, and other investment advisor, although we also have our own investment advisory. So we really just want to be a partner that's there, however you develop your trust and estate plan, to work with you and provide the greatest amount of protection and ease in being able to pass your legacy on to your children, and also to business succession plan for your farm. And with that, I will start. So, considerations for the family farm. We want to understand your objectives. We want to understand, do you want to keep the farm in the family? Is there sentimental value? Is it a wealth accumulation? Is it, a family unity structure and heritage? How long has the family farm been in the family, and what those interests are? And what do you want to do with the farm for generations to come? We also want to look at the objectives. What are the obstacles that you might face? Maybe it is in-laws. Maybe there is one child that you're worried about, or one other family member that you're worried about. Perhaps you have concerns about creditors or bankruptcy, or you are worried that not just worried, but there's a consideration that there are heirs that may want to cash out. And there could be disagreements on the operations of the farm that you're concerned about. Maybe there is discord, and you are worried that when you try to pass the farm on, that the family could involve themselves in litigation. And of course, there's always the consideration that there might be the inability to afford to keep the farm. And what we want to help you think about is fair and equitable. And in the passing of the farm, fair doesn't always mean equal. And that is a concern as well that we would talk with you about and plan for. It is a particular concern if there's no succession plan created. That's with any business, and we run across that all the time in our business, and that's what we are particularly here for. That's why in our small boutique firm, entrepreneurs and business owners are a major focus of ours. We want to help you when one of the considerations is that you might be unable to meet your financial obligations, and of course that you are worried about keeping the peace in the family. And how do you handle when inheritance is locked up for families that are not on the farm or particularly related in the operations of the farm, and might not want to be? And what happens when you have too many heirs for too little interests? We also think about that, and too little to pass on. So we want to deal with all of those relationship issues as well. There are a lot of issues even that you might not even think about coming to the forefront. Some of these can be communication problems, family structure, commitment to the farm interest. Maybe you're worried that there won't be transparency after your passing, or the business are you ready to pass the business on. Perhaps you're worried about different personality styles clashing amongst those that you want to pass the interest to in your family or outside of your family. And it certainly will be that, let's take in the case of you wanting to pass the farm on to your family, that you may have children who are in different life stages. And that there might be boundaries such as state boundaries that are a consideration as well when you're talking about your beneficiaries. So as Doug mentioned, we really want to look at the farm as an overall part of your estate. And we look at this as what makes up your estate, and what is your family structure, and what is the structure of the farm, and where do those coincide. That is where we come in and Doug comes in to play as far as the planning piece and what we want to do to move forward. And look at those family dynamics as well, because I often say to clients, we can be empathetic without being emotional. And that is certainly what you depend on Doug and I to be for you when looking at your estate plan and how to pass on interests in the farm, and also how to build a succession plan for your business. And you will have stakeholders in this. Perhaps they're different family members who are not active in the family business, and one or two that are active in the family business. This is irrespective of farm families. This is what we run into with all of our businesses that we have as clients. They're just the facts that about family business sustainability. 90% of U.S. businesses are owned and managed by their families. 30% survive typically into the second generation, and only 12% typically survive into the third generation. What we want to do is divide, for planning purposes, the operations from the estate planning when it comes to the land and your family farm business. So again, we would focus on the box on the left, the estate box. And some of this, I'm just going to go on down because some of this Doug clearly touched on, and I don't want to go too much over what he was talking about, but we want to help you set goals based on what your vision and values are, and your family structure and the structure of your family farm. So we clearly want to help you protect your kids and family, minimize your taxes. To the extent that you want to involve charitable giving, we can also help with that as a part of your overall estate plan and trust, and clearly avoid probate. So as Doug mentioned, what is a trust? It is a legal entity that holds and manages your assets for the beneficiary, for the benefit of the trust beneficiaries. You as the owners would be the grantors. Cornerstone is a professional trustee. Doug just for a moment touched on professional trustees versus perhaps a family or other disinterested party as a trustee. And there are certainly pros and cons to all of that. And that's why I mentioned just a moment ago, we like to say that we are empathetic without being emotional. And that can be part of the drawback of choosing, especially one or more of your children as a trustee, or another family member who might be too close to the situation to truly make those decisions that we think more reflect what you tell us are important. Because let's face it, a trust is the best way for you as the grantors of the trust to reach back, if you'll forgive the gravity, from the grave and still control interests and how you wanted your vision and values and legacy to look. This is your venue for doing that. And so when you have someone that is not as emotionally attached, they are able to know what that vision and value what vision and values you had talked to them about, and carry that out for generations to come. And as I mentioned, Cornerstone is a South Dakota trustee, and there are many advantages to that, not the least of which is asset protection. So the estate process, and Doug talked about this just a little bit, but so we would both prepare, or your attorneys and trust folks would both prepare what your strategy would be based on your vision and values and your business and the strategic vision you have for passing that along, especially through legacy. Doug would be, as an attorney, drafting the documents and reviewing them. And both Doug and I would work in conjunction to implement those, to transfer assets to the trust. And I'll talk a little bit about the LLC as one vehicle of that. And Doug talked to you a little bit about land companies, which also work almost the same exact way. And then as the trustee, we would monitor and recalibrate as needed, looking at the plan, taking into effect any changes in law that might affect the trust and its administration, and making sure that we were working with the beneficiaries of the trust as you had directed that we should. Sometimes that is looking at the income and how do you want, the trust income to be passed on to beneficiaries. Maybe that's the first to die, as Doug mentioned. Maybe that income is going only to your surviving spouse. Maybe at the second death, then it's going split between interests, the beneficiaries of the trust. Let's just take, for instance, that there's 3 beneficiaries, 3 children. Then we would be splitting that according to what you had told us you envisioned, and we would administer that. Or looking at principal distributions and talking about what those would look like. So when we look at planning for the family farm, there are a few things not to do. We as trustees typically would advise not to put the farm in tenants in common. There's a variety of reasons not to do this, some of which Doug touched on earlier. But it can provide some unintended consequences when you talk about passing in joint tenants in common. Other considerations are that when you give it by will, that you are running into these sorts of problems, that there's rent without consent, that there may be the possibility that there's not proper reimbursement for repairs. There's all kinds of things that can happen that are unintended when you do it through tenants in common versus a trust, where you truly can have more control of how those assets pass from the grave, as I mentioned. And there is also unintended consequences for the last to die, inherits everything, and other heirs would get nothing. So the solution, we think, that provides the most flexibility, and some of you indicated in your poll in the beginning that you had already, I believe maybe 2 of you have formed LLCs around your farm business. So congratulations to you for being on the forefront of protecting your farm assets. And we do highly suggest forming an LLC. It's a legal entity that's formed under state law. It's very simple to form and very simple to transfer assets that would be intended to be held within the LLC. So then an LLC can then be held inside of your trust. And especially for a South Dakota trust, it adds an even more protective layer for your assets from creditors and or from the instance of divorce. And exactly the bottom line: no hurt feelings, no angry exchanges or estrangement, no litigation. It's very, very clean answer to avoiding all of those emotions and problems and unintended consequences. As I said, that LLC owners are shielded from liability. It prevents filing of partitions. It passes through taxable income and losses. It's a perpetual existence. And there are plans for both entering and exiting the LLC. And I would say of particular interest for the folks on the call this evening, a founder control for as long as the founder desires, and separate control and equity interests. For instance, the farm land and farm debt, you have mom and dad, and they hold the farm jointly, and they can transfer to the LLC land and debt. You can do this a variety of ways. Maybe mom or dad have 1% managing, and then the rest limited partnership. So then you talk about voting rights and distributions of interests. And then you can, when it comes to the income, then you can siphon off those distributions and also be able to take advantage of cash distributions through K1, so then you have favorable tax treatment as well. And I'm trying to keep this high level because I know for some of you not having them, it is a lot to take in. So I just want to mainly get across to you the fact that it is an excellent way to hold your interests, to have the ability for creditor protection, and to be able to pass the farm on in legacy through trust. And this is just another way that you could be able to do this if you look down in the cash mom and dad, the 15% stakeholders, those would represent your children as beneficiaries and how these would pass, and also tax treatment. You can also, as I mentioned, that's entering the LLC. You can also have very easy ways for exiting those liability interests as well. And maybe for whatever reason, for whatever instance, and we talked about earlier that your children may be in different life stages, and for whatever case, they may have different reasons for having to exit that LLC as well. And then we would have ways of doing that and or loaning against their interests. That would be an instance where they needed liquidity, and we could help provide that to them. And you can have when you have an LLC, and that also provides the availability. One heir can lease the farmland, one heir could purchase the farmland. So it's just a lot of flexibility that happens within the LLC, and that LLC within the trust. Again, talking about family business transition of the estate and business and your stakeholders, which again is very important to think about if you have stakeholders at different levels of involvement in the farm, active versus stakeholders. So you have, apologize. The farm operation may be a joint venture. You may have two sole proprietors, or you have it as an entity, and you can have formal communications, define goals and roles, transparent financials. All of this happens through this LLC and having an operating agreement for just those particular instances. And you can even get very specific about what happens with land rent and machinery usage, ben rent, shop space, all of those things. So again, a lot of control with added protection. What doesn't work? I can tell you from the amount of time that I've been with Cornerstone, ignoring family dynamics, lifestyles, family versus business partners, in-laws. This is not the time to put your head in the sand and not think about these things. This is the time to acknowledge that these things may happen and take an active role in making sure that you choose a plan that mitigates those types of things for you. And ignoring, the informal agreements that take away the flexibility and nature that you would like to use and employ during your lifetime. You want to make sure that you don't ignore the IRS rules, and you want to make sure that you are not ignoring, not funding sibling buyouts. So with that, I would just also mention that it is very important, we think, to work with an attorney. We would highly suggest forming an LLC that would the farm business would be owned in, the farm land could be owned in, different parts of the farm could be owned in, and then putting that inside a trust so that you could ensure for the most flexibility, the greatest of asset protection, and to pass your legacy on with your vision and values, how you see fit. And we would be honored to be able to help you work on that plan within Cornerstone as the professional trustee. And with that, I'll turn it back over to Maggie. I believe we could have time to entertain some questions.
Yeah, thank you both. We have plenty of time to get some questions in, and we did have some come through the chat box. So I'm just gonna start back at kind of where the questions first started coming in. Someone asked about tips to help avoid probate.
Right. I can address that if you'd like.
Yeah, if you'd like to take a second to.
Sure. So really, tips to avoid probate. You can always avoid probate with transfer on death, beneficiary designation, pay on death, and joint tenancy with right of survivorship. Remember that those sorts of things for avoiding probate can carry their certain problems. If we have joint tenancy with right of survivorship with our child, that asset then is subject to our child's creditors, and that may or may not be a good idea. The sort of the tried and true method to avoid probate would be to have the asset transferred to the trust. Okay, so even if we own our checking account while we're alive with our spouse or alone, on our death, we can say that transfers on death straight to my trust. And there's no probate. Okay, so then we don't have that public process that your neighbors get to go look at if they really want to. So those are the ways to do it. We think a trust is an excellent way to keep everything private.
Absolutely.
Great. So there was another question, and this might have referred to a specific slide that it'd be hard to answer, but I think it was around when you were talking about, Doug, what happens at the second death in your case study, and you had a phrase titled properly on one of the slides, and they were asking for clarification on what that meant.
Okay, so what I really mean is, and a better way to have said that may have been to have said properly transferred into your trust, or titled into your trust, or assigned into your trust. We just want to make sure that if we have real property, we've transferred that by way of a deed. If we have property that actually has a title, we have the trust hold it. Now, usually automobiles, we don't do that. With non-titled property, we might assign that to the trust, say, as we would with a limited liability company interest or a stock interest or something like that. We can also do what's called a beneficiary form to get certain financial assets into the trust, like LLC interests and things like that. So there's many different ways to get it what I call titled properly, but that just means to make sure that the asset that we want to avoid probate, we get that into the trust. And there's several ways to do that depending on the particular asset.
And it's very, I would think Doug would agree, a very simple process, working with your attorney and trust officer to do that. And you can even divide up, shop interests, as I mentioned, shop interests, equipment interests, and land interests, if that is a cleaner way or preferred way of doing that, and forming separate LLCs, even down to that level, and then getting those assets into the trust. But it is imperative to have them properly titled so that you can make certain that there's no way they would transfer any way except through the trust and by your intention.
Right.
Great. Another question is, do you have any thoughts about setting up conservation easements on portions of the farm?
That is beyond my...
I would have to agree that that's a little bit beyond my wheelhouse as well. I would imagine that would be according to state law. And
well, I think conservation tax increment or conservation easements are actually can be in the state tax code, but I think they're also a part of the federal tax code. And I think it's a little bit difficult, but I know it can be done. And while I may not be able to do it, I bet you that I can find somebody in my office who can. And so if that is something you're really interested in, we can give it a whirl to at least look into it for you. And if we can't do it, we can find somebody who can.
Right, exactly. And that's, just another advantage of, having these the folks in the estate plan process at your disposal, because then you have this concert of people that are subject matter experts that can look at all of these particular situations. And if they don't know the answer, they can help find it. And again, whatever the case may be, whatever the particular reason or vision you have for accomplishing something like that, then you can make certain that you have subject matter experts that are helping you to accomplish that and make sure that it's part of your overall plan and what the tax advantage is or isn't.
So then we also had a clarifying question. It was when you were talking about, I think it was Amy, when you started off and you were talking about Cornerstone being located in South Dakota. So they asked, so even if we live in Iowa, if we hire professionals in South Dakota, we can use South Dakota trust law.
So yes, you would, or because you would have a South Dakota trustee, then you are able to take advantage of South Dakota law. There are some caveats on that. So of course we would want to do a case-by-case analysis, and we would do that in concert with your attorney, such as Doug. But yes, our operations are in South Dakota. We have a junior trust officer in South Dakota. I happen to be in our Minnesota relationship office and am a trust officer, and I can work anywhere in the country with anyone and be able to organize under South Dakota, the trust under South Dakota law.
Great. There's also a question, what are the pros and cons of gifting to a child and retaining a life estate? So the person said, Doug did not mention gifting to a child and retaining a life estate. What are the pros and cons of this?
So my first read of that question is my problem with life estates are this. I've had clients come to the office and they say, well, my dad gives me this property and he gave it to me such and such a way or whatever. And I don't like that it's given to me that way, because it's going to create a problem or something like that. Well, the problem with a life estate is it's irrevocable. We can't change it. So here's the scenario. We give our child a piece of property, and then our child marries somebody who is awful. Then our child dies. Now we're kind of sharing that property with somebody who we think is awful. And we can't change it. We can't get out of that relationship with that person. And as a life tenant, you do have some duties and obligations not to waste the property that's going to go on to the
remainder.
Yeah, to the remainderment. So I just don't care for that kind of planning. I've seen it. People think that maybe it will work for, nursing home planning, and it does not. It absolutely does not work for nursing home planning. So I just haven't found a lot of use for it. I can imagine there are times when it would work and it would be a great idea, but you need to understand it's irrevocable. We can't change it. And so, who knows if we're going to feel the same way 10, 12 years from now as we do today about giving this piece of land to this particular person. Are they going to be the same person? Are they going to be, are they going to have the same relationship? So that's kind of my take on that. There are some advantages to it, but it's an easy way. It avoids probate, and it's pretty simple. It's pretty cheap. But I just think the disadvantages outweigh the advantages. My personal opinion.
I would just add to that, when you are looking at your estate, you want to think about what kind of control, what kind of legacy you're wanting to leave, and how much control you're wanting to have in that. And that situation, as Doug so aptly put, takes that control out of your hands, or some of that control out of your hands. So, you have certain vision values I've talked about several times on the call. You have certain goals that you have, certain ways that you see your legacy. And our thought would be you would want to have as much control as possible in how that plays out over the course of time.
So we also have a couple questions about LLCs and other entities. So someone asks, would an LLC be preferred for a group of sibling investors?
Well, if Amy's not going to jump in, I'm just going to jump in and say resoundingly yes.
Yeah, I was going to say absolutely. It would be absolutely the preferred way.
Absolutely, resoundingly, we can't wait for a group of sibling investors.
Perfect.
And there's a lot of different ways to do it. We can keep the in-laws in and the outlaws out. We can, determine how it's going to be transferred, and then that's just a great way to plan.
Yes. Talk about titling properly.
Yeah, exactly.
And I think a follow-up to that would be, if there was a group of siblings that was starting to have a discussion about forming an LLC, is there a best approach to that? Is it a matter of just getting everybody and sitting down and talking about if that is the preferred option, or should when should a professional be brought into that conversation? Could you talk a little bit about that?
So I've had this very situation. In fact, we have it more often than you'd think, where like a group of siblings inherits land from mom and dad as tenants in common. Okay. And that it just seems to happen a fair bit. So, say we got, 4 quarters. And so we got a section of land and 4 siblings get it. And they really, they're thinking about it. Usually what happens is we end up talking to one of them at the outset. And the first thing is to get everybody in, because everybody needs to be in on the meeting at the outset. And what I mean by that is, so the best way to do is a lot the way Amy started her presentation. We start out at that 20,000 foot level for everybody. And then the questions will start to drill us down into, the 10,000 foot level. And then we can get very granular on how to set this company up. Okay. And so it's very good to have a group meeting. And a lot of times I know, in fact, this is one of the frustrations or one of the difficult things about these meetings. As the lawyer or the professional, sometimes it kind of feels like herding cats, because you're trying to get all these people on the same page and they all have different questions going in different directions. But it's good. It's a good way to let everybody kind of understand how this plan can work and how to decide how much control we want to keep inside the company, how much asset protection we want to keep inside the company, if we want to just use the company for management purposes, if we want to use it for liability protection. Maybe we've got a management part of the company and an asset holding part of the company, and then we might consider more than one LLC. And so to go over these things with everybody as a group to get everybody's questions out, it helps to kind of get the whole dynamic of the whole family, and then everybody kind of gets on the same page. And as you kind of develop that, everybody into the same page, maybe somebody doesn't want to be part of it, but we want to make sure everybody who does want to be part of it gets in on it, and then gets their interests put together in maybe the LLC or maybe a land partnership, or there's just different ways to do it. And in Iowa, we're probably going to use more LLCs, but very, very good ways to do that. And then we can just drop them into the South Dakota Trust if we want to. We don't have to. We can use an Iowa trust too.
Absolutely. And I would say too that it's a great way, especially when talking about family farms, of handling active versus non-active, or one wanting to be, bought out of the interest, like whatever the case may be. It's an excellent way of sitting down around the table and finding out really just where is everyone at and where do they want to be.
Right. And those meetings can take some time, but I think it's time that can be well spent.
And we had another question related to this come in. The attendee asks, if the sibling LLC is formed, does that prohibit me from investing in my own personal LLC for purchasing farmland separately from it? Isn't there an Iowa law that prevents this?
I don't think so, but you've got this in your head, so you got it somewhere. And I think the answer to that is that you can have, an individual can have multiple limited liability companies.
Absolutely, with totally different purposes and structures and ideas behind them.
Yeah. So I don't think that's going to be an issue.
Great. And then somebody asked about the advantages of an LLC versus an S corporation.
Basis. So what I mean by that is this: we never ever put land into an S corp because it causes problems with our basis. In the LLC is treated like a partnership, and so it's the basis of the individual, and it stays that way whether we take it in or take it out. If we put land into an S corp, when we take it out, we have to recognize gain, and that's a problem. So S corp is, for a land company, an S corp is fast becoming a thing of the past. It's going the way of the 8-track tape. Showing my age.
We should be careful about the age level on here. They might not even remember, like you and I, Doug. Who knows?
Who knows? But anyway, I'm not a fan of S corps in family farms.
Agreed.
So someone suggested from an earlier discussion that the Sustainable Iowa Land Trust would be a good resource for information on conservation easements. And then we had a question, how do you feel about checking with the AARP Foundation as a first step in estate planning?
In my mind, the more information that the client has, if they've got good information, the better, the easier my job is.
Totally agree.
Yeah, so, and I think I've not reviewed AARP Foundation information, but as a general source of information, sort of like my disclaimer at the beginning, yeah, it's a great way to learn some basics and to get some ideas. And then, go run them by your lawyer. But the more you know, the better off you're going to be able to guide your plan and make your plan fit you and your circumstances.
Absolutely, totally agree. It's got to be something that is based on your goals, your objectives, and with your understanding. And the better that you understand what the plan is that you're putting in place, then the better you'll be able to drive that process as well and be a great partner in how you want your business and your legacy to be passed.
Well, we have just a couple more minutes. Does anybody have any last questions that they'd like to put out on the floor for either Amy or Doug or both of them to answer? If not, Amy, Doug, do you have any last parting words? We have your contact information here for folks to jot down or, look you up with. But yeah, Amy, Doug. We just had a question. How do you start the conversation with parents?
Well, you tell us.
Yeah.
I think the one thing is this. The conversation with parents this is one approach that you might use is, hey, look, mom and dad, we know that at some point this farm may pass on. And if they agree with that, then say, how do you want that to happen? And listen to what they say. And if they think they want to keep it in the family, if they want to keep it a farm and they want to keep a family and a farm, just say, we know people who can help. And take them to a place, if it's not Thompson Law or if it's not Amy's place, or Cornerstone, find an attorney who does estate planning, but not an attorney who is doing a DUI case one day and they're suing somebody for divorce the next day and they write a will now and then, because those guys, estate planning is a very, very broad and very, very deep field. And there's just a lot to know. And if you do it every day, I think that's the deal is somebody who does estate and trust work every day is the person to bring your farm problems to, and somebody who works with farmers.
I was just going to add in someone that works with farms is so important and has a passion for that. And I think, when you have that conversation or when you're trying to start that conversation, I would suggest that it would be more about encouraging them to understand, the parents to understand, we want to know what you want so we can help you do that. I mean, even if your interests differ, or even if what you hope is the outcome is not where they are starting from, at least you're starting the conversation in a way that opens dialogue and doesn't immediately cut dialogue off.
Yeah.
And I don't know if there are further questions, but I was just going to say that I can't speak for Doug, but I am definitely happy to travel to Iowa anytime to meet with folks, or if they prefer doing it over the phone or through video, that's fine too. But I always feel like stepping into someone else's comfort zone and territory really puts them at ease. So I would say, just from my standpoint, I'm more than happy to come and meet with you and help the dialogue and the conversation. And would encourage you to contact me, and would look forward and feel very fortunate to work with you.
We did just have a last minute question slide in. If land is held in trust, do you have the same opinion about LLCs?
Yes.
Ditto. Absolutely.
All right, Doug, do you have a parting word before we close things?
Well, I think Amy said it very well when you know, when you get that conversation started with you or your spouse or your parents, we are here because that's what we do. We focus on estate planning, and we are passionate about that. We don't. Probably not going to make an out-of-office visit because we may have a couple of meetings with people a day, and it's maybe not practical for us to you know, drive that far. But we're always available by phone. We're always available by email, and we've got time available to meet, and we're just ready to go.